Tennessee is now in session.
With leave of court, the state wishes to reserve 3 minutes for rebuttal.
Counsel, just a second. Let me say a couple things before we start here, before we call the case.
Thank you, Your Honor.
That's fine. First off, I want to appreciate all of y'all participating in by video here. The technology has been working really very well, thanks to Mr. Hibner and the AOC IP personnel. But if we should have a tech problem on anybody's end, don't worry about it. We'll just take a pause and we'll, when I say we'll fix it, they'll fix it, and then we'll proceed. Your panel, well, I have Mr. Hibner call the case first.
Metropolitan Government of Nashville and Davidson County et al. Versus Tennessee Department of Education et al.
Good afternoon again. Your panel on this case is Judge Andy Bennett lives in the Hermitage. I understand it. Judge Neil McBrayer is Brentwood, and I'm Judge Mike Swinney from Knoxville. We'll hear from the appellate now.
With leave of court, Your Honor, the state wishes to reserve 3 minutes for rebuttal.
That'll be fine.
Thank you, Your Honor. Good afternoon. My name is James Newsom of the Tennessee Attorney General's Office. It is my privilege
May I ask a question first?
Yes, sir.
You have 15 minutes, right? And then it's going to the two of the interveners for 7.5 minutes apiece, right?
That's correct, Your Honor.
Okay. And then it goes to Mr. Cooper. And are you splitting? Are you doing the whole half hour? Or?
Your Honor, no. I had asked the state has 15 minutes, and we've asked to reserve 3 minutes for rebuttal.
Right, but I was asking Mr. Cooper if he was going to do the whole half hour for the appellees.
You need to
Can't hear you.
There we go. Okay. Yes, Your Honor. I will be the sole attorney arguing for appellees.
Well, good for you. Okay. I just wanted to get it straight in my head how this was going to proceed. So thank you very much.
Thank you. And Mr. Hibner, do we have 12 minutes?
Mr. Hibner, if you would start it back at 12 minutes. Thank you.
Thank you, Your Honors. Good afternoon. My name is James Newsom of the Tennessee Attorney General's Office. It is my privilege to represent the defendants below, the Tennessee Department of Revenue, its commissioner, and Tennessee Governor Bill Lee. If it pleased the court's May 19th order granted Rule 9 interlocutory review on 2 issues. First, whether the trial court erred in ruling that the ESA program violates the Home Rule Amendment. And second, whether the trial court erred in ruling that the county government plaintiffs have standing to challenge the constitutionality of the ESA program under the Home Rule Amendment. We submit that the court should reverse the trial court on both grounds. First, the Home Rule Amendment. The ESA program does not legislate regarding a matter of local affairs. It legislates in the area of education policy, which is a state function. The Home Rule Amendment does not vest control over education policy in county governments. The counties request that this court read the HRA in a manner that exceeds the maximum permissible extent of their local powers under the state constitution. The county plaintiffs argue that funding of a student's participation in the ESA program includes local funds and that the program therefore requires local approval under the Home Rule Amendment. In Small Schools 1, the Supreme Court stated that the means by which the General Assembly's constitutional obligation to provide educational opportunities to Tennessee's school children is a legislative prerogative. The system may include the imposition of funding and management responsibilities upon counties, municipalities, and school districts within their respective constitutional powers.
And why doesn't that give the county, and why doesn't give that give the county standing because the state has involved the county in funding and arranging for bonds and other things for the school systems.
The short answer to that question, Your Honor, is that the responsibility for education is upon the LEAs, or the local educational agencies, and not the counties themselves. And so what has, as in accordance with the ESA program, there is no additional burden that is placed upon the municipalities by virtue of the ESA program. The children,
the local, the LSAs, in this case, they consist of all the schools in the counties, right?
they consist of
All the metro schools are one, right?
In Davidson County, that is true. It's the Metro Nashville Public Schools. In Shelby County, it's the Shelby County schools that are involved.
So what difference does it make whether you call it an LSA or just say the county school system?
Your Honor, it's the same parlance. It's just the legislative parlance that has been adopted to call the school boards the LEAs under the current law, Your Honor, and that's why we refer to those as the LEAs.
But the LEAs are just the county systems. So you're saying the county's not involved, but you just changed the name.
No, Your Honor, we would disagree. In the court's recent opinion in Young versus Stamey, the court points out that municipal school boards are not mere appendages of cities or of counties. They enjoy a high degree of autonomy. Like county schools relative to county governments, they perform separate functions. Your Honor, we submit that functionally they are much different, and that the LEAs are an arm of the state itself, according to the statutory scheme. The Justice Reed in the small schools case laid out the constitutional scheme in reference to education policy. The taxing clause authorizes the legislature to give counties and municipalities the power to impose taxes for the support of education. The spending clause, Article 2, Section 24, gives the General Assembly the widest discretion in assigning the relative degrees of responsibility of the state and the local governments for funding state-mandated services. The state may require a county to appropriate funds for a state purpose or for a purpose common to both state and county. In Justice Reed's words, it is clear that the Constitution gives the legislature the greatest flexibility in determining the allocation of responsibilities between state and local government. And this is particularly true in respect to education policy. In the legislature's authority over education policy has long been recognized. As early as 1926, in State Ex Rel. Harned versus Metter, our Supreme Court held that the public school system is a matter of state and not local concern. They said whether or not there should be a uniform system of public schools is a question of policy, which is addressed solely to the legislative department of the state. That power does not infringe upon the right of local self-government, because a school system, like a highway system, a penal system, or public health, is not of purely local, but of state concern. And Metter remains binding authority. In 1988, the Supreme Court decided State Ex Rel. Weaver.
Counsel, let me take you back before you get too far away from it. You mentioned Young, but in Young, we acknowledged that the school system depended upon the county for its funding, correct?
Correct, yes, that's right, Your Honor.
And all we said, and what the opinion said, was that school system enjoys a high degree of autonomy. We
Correct.
didn't say that the county had no involvement in it, did we?
Oh, and that's not our position, Your Honor. But the county's involvement is dictated by the state law. And I think
I'm sorry, I didn't mean to interrupt, but I will because your time's getting short.
certainly.
So the Davidson County and Shelby County taxpayers who pay their taxes to those two counties respectively have no say-so how those tax dollars that go to those counties are spent as far as this money.
Well, Your Honor, what occurs under these circumstances is that the BEP requires a certain amount of contribution that has to be made from county derived tax funds to education. But what we know is that it is that is required by state law, and so the LEA is funded by means of that taxing authority, and that the role of the county commissioners, as Justice Strwoda points out in State XRL Weaver versus Ayers, is essentially to make sure that the county's contribution or taxes do not exceed the fiscal capacity of the county itself by way of taxation to provide funding to the system.
Well, practically speaking, don't county commissions essentially have the power of the purse? And if the school system is spending money or in their proposed budget in a way that the county doesn't like, the county can not pass the budget.
Well,
Right.
Your Honor, there are certainly limits on that, and as Justice Strwoda pointed out, it's a very limited role that the county commissioners or that the county have under these circumstances. And again, it is to determine whether the capacity of the county to fund education has been exceeded. But neither Davidson nor Shelby County are raising that as a concern here. They're not saying that if these children who are affected by the ESA program are in private schools versus the schools that they operate.
But you are minimizing the role of the county commission.
I'm sorry.
But you are minimizing the role of the county commission. And my point is, sometimes county commissions play a bigger role in the budget than you're saying, because they exert pressure for the school system to spend or not spend money in certain ways by the ability to fund or not fund the budget.
Well, the BEP program puts limitations on what can be done. As a matter of fact, if the county funds to a certain level, the BEP includes a maintenance of effort. And Your Honor, for the same reasons that we assert that the Home Rule Amendment is not violated here, we assert that the counties lack standing, because the claim that they are asserting here is really not their own to make. It's the claim of the LEAs. And so under the circumstances that we have here—
You argue the LEAs themselves don't have any standing? I mean, under your theory?
Well, Your Honor—
This is all within the province of the state.
The LEAs, Your Honor, are an arm of the state, and in that capacity, the LEAs may not sue the state itself, Your Honor.
So no one has standing?
No one has standing under the Home Rule Amendment to challenge this. That's our position, yes, Your Honor.
Okay.
And I see that my time has expired.
It has. You have your time for rebuttal.
Thank you.
We'll hear from who's next.
Morning, Your Honors. My name is Arif Panju. I'll be arguing on behalf of the intervener defendant appellants Natuba, Bulgaisi Diallo, Bria Davis, and Star Brumfield. The intervening defendants have advanced distinct arguments pursuant to our agreed order on intervention. So the Home Rule Amendment has three different inquiries. I'm going to focus on the second half, which is whether the law is applicable in a governmental or proprietary capacity. I'd like to reserve 1.5 minutes for rebuttal. Until the ruling below, Your Honors, no Tennessee court has ever construed the text of the Home Rule Amendment so expansively so as to empower counties to extinguish the direct benefits, the direct state benefits of their own constituents. And in that sense, Your Honor, plaintiff's entire case hinges on stretching the term of art applicable in a governmental or proprietary capacity beyond its plain meaning and beyond what the case law will support. Indeed, plaintiffs advance not a single case that supports their theory, which is that the law is subject to the Home Rule Amendment merely because a law affects a county's finances. Now, plaintiff's theory for this expansive reading, like I mentioned, finds no support in the case law, so I will focus my argument on what the case law tells us. And the case law that has developed the term of art governmental or proprietary capacity has developed that term of art in the narrowest of senses. And to fall within its scope, a challenge law has to act upon a county as a county entity. In other words, a law must impact the nuts and bolts of what makes a county a county. And this term of art has consistently been applied regardless of whether or not a law impacts a county's finances. For example, in Chattanooga-Hamilton County Hospital Authority v. City of Chattanooga, you had a case involving the City of Chattanooga and Hamilton County jointly owning hospitals. And there was a stay in place at the Tennessee Supreme Court, and they were asked to review whether the Home Rule Amendment applied. Now, despite the financial impact of being forced to transfer entire hospitals and all the revenue that comes with those hospitals, the court found that the Home Rule Amendment applied only as to the county, but not as to the City of Chattanooga. And the reason why animates how this court should apply the Home Rule Amendment. It applied to the county, Your Honor, because the law in its face said, look, this hospital district is going to, quote, act on behalf of the county. In other words, exercise the power that the county has, but not the City of Chattanooga. And so despite the fact that there was transfers of entire hospitals, and despite the fact that the City of Chattanooga had a partnership with the county, jointly owning these hospitals, the Home Rule Amendment did not apply. Moving to an earlier case, Parrott v. Carter, involving the expansion of a special school district. Here you have a law that allowed a special school district to expand its boundaries in Carroll County. The district was expanding its authority over county territory. As we note in our reply brief, citing the same sources that the plaintiffs rely on, first saying that special school districts are independent. Counties partially fund special school districts, yet despite the financial impact, it did not matter how or what was affected. What mattered is that a special school district was not a county or municipality under the meaning of the Home Rule Amendment. In
Did you
other
say
words,
the county partially funded the special school district?
I'm sorry, Your Honor, could you repeat the question?
Did you say the county partially funded the special school district?
What I note is that special school districts, according to the city's own authority that they cite, are partially funded by county governments. They cite the Tassier report, where the Tassier report notes that special school districts are independent because they can raise money themselves and they can approve their own budgets. But despite that, independence does not mean that they don't have any financial support. And regardless of whether they're funded, expanding the scope over county territory and displacing what was there had clear financial impacts. Yet despite displacing authority, the court did not delve into any inquiry into what kind of impact on finances took place. In fact, not a single time in the entire jurisprudence has any Tennessee court delved into an impact on finances to determine whether a law was applicable in the governmental or proprietary capacity. And that makes sense, Your Honor, because for a law to be applicable to a county in that capacity, mere financial effects are not sufficient. You need something more. And to see what that more is, we need to only look at the case law more broadly and look at just the cases where Home Rule Amendment claims were successful, regardless of
Why do cases say that financial impact is insufficient?
Well, so I think our argument is that there is no case that says that financial impacts are sufficient. We can highlight two cases.
Are there any that say they're insufficient, or do they just not address it?
They just don't address it, Your Honor. It's simply because the mere fact that there were financial impacts was not relevant to the analysis. And that's our argument. And that follows and is consistent with the broader body of case law. And if you look at successful home rule amendment claims, you see cases like Ferris v. Blanton, runoff elections, which directly impacts the nuts and bolts of county government, who will hold the levers of power. First Utility District of Carter County v. Clark, appointments to commissions. Well, yeah, that affects the nuts and bolts of who's going to sit in those commission chairs and make decisions. Durham v. Dismukes or Lawler v. McCandless, expanding the jurisdiction of county courts, which impacts a county's power to adjudicate legal disputes.
What does it mean when it acts upon a county in its proprietary capacity? What does that mean? You address governmental, but what about proprietary?
A proprietary capacity relates to exercises of the county government for its own purposes and objectives, whereas governmental capacity relates to the administration of governmental power to fulfill whatever an obligation that the state may require.
Well, the way you're defining this term of art makes me wonder why the Supreme Court has said that the line of demarcation between impacts on counties as a governmental entity is so difficult to determine in cases.
Right, you're right. I think Your Honor is referring specifically to the equal protection cases where this term of art received pronouncements from the Tennessee Supreme Court prior to the ratification of the Home Rule Amendment in 1953. And we would point to those cases as showing like the line of demarcation may be hard to determine in some cases. But the fact that the case law treats those as polar opposites, it's either a direct benefit or it's acting upon the county. Here we have a clear direct benefit. It's at the other end of the spectrum if you view how the Supreme Court has viewed the term of art vis-a-vis direct benefits. And we would say, Your Honor, that just like those pronouncements rely on the nuts and bolts of county government, what makes a county as an entity, that meaning from the equal protection cases has to be imported into how the court construes the amendment's text here. Of course, it's a cardinal rule of construction to import the cluster of ideas that are baked into the common law. And we have to assume that the drafters knew about those when they enshrined that term of art in the amendment. I see my time is up, Your Honor.
Well, that's okay. Let me ask you. So you're saying the home rule amendments does not apply because, just give me kind of a conclusion.
The home rule amendment does not apply in this particular case, Your Honor, because plaintiff's theory, which relies on mere financial effects by way of a partnership with a school district, is not the type of law that acts upon the county within the way that it operates county government. It's not about appointments or elections. It's not about someone stepping in and acting on behalf of the county. This is a benefit program for direct benefits to Tennessee citizens. And if you look at what the scope of power for the counties in this case includes, it excludes the ability to interfere with education choices pursuant to their own charters. And the Home Rule Amendment in paragraph 5 makes clear that counties adopt charters to provide for their governmental or proprietary powers. And so if those powers never existed in the first place, there is absolutely no way that the plaintiffs in this case can do an end run around their charters, invoke the very amendment that helped them get those charters on the books, the Home Rule Amendment, to interfere with educational options.
All right. I mean, the Supreme Court stated that they reference it, and it's in Civil Service Merit Board versus Knoxville, and they referenced their opinion in, I think it was Ferris, that the sole constitutional test must be whether the legislative enactment, irrespective of its form, is local in effect and application. I mean, you agree with Supreme Court that that's the sole constitutional test?
As it relates to the first part of the inquiry, Your Honor, the threshold inquiry, whether a law is local in form or effect, which is what the Ferris case was about. And the very next sentence, as opposed to being the sole constitutional test, which is what we're looking at in the Ferris opinion, that quote comes from that opinion, is the predicate before it goes in and analyzes whether the law was local in form or effect. What our argument is let's assume that the law is local in form or effect, and let's assume that there are financial effects, which we disagree with. You still have to have a law that's applicable in a governmental or proprietary capacity. That inquiry, Your Honor, requires delving into whether a law is acting upon the county as it exists as a county entity.
Well, whether the test is not just whether it acts, but whether it affects.
The local in form or effect inquiry, the first part of the Home Rule Amendment's inquiry, which was at issue.
I understand what you're saying, but where you're coming, I think the ultimate conclusion is, or I think, correct me if I'm wrong, what you're saying is that the tax dollars of these citizens, taxpayers in Davidson County and Shelby County, when they pay their money to those counties, the fact that is now being directed someplace, a portion of that money is being directed someplace else, does not affect the county because it involves just money.
Right. In terms of whether there's an effect at all, Your Honor, we would argue that whatever the financial benefit.
No, okay, but my question, am I right? Is that what you're arguing? Is that it just involves money, and so that's not really an effect on the county?
Yeah, mere impacts on a county's budget are not sufficient to satisfy the second part of the Home Rule Amendments inquiry. That's correct, Your Honor.
All right. You've got your time for rebuttal.
Yeah, it has narrower language than the local informer effect. And that's what.
All right. Yeah, thank you. You have your time for rebuttal. We'll hear from next.
Good afternoon, Your Honors. Brian Kelsey on behalf of the Greater Praise Intervenor Defendants, and I would like to reserve 1.5 minutes for rebuttal. Thank you. Thank you very much, Your Honor. Let's have 3 brief arguments to make, but let's skip straight to standing. And we have a different argument, but it's similar to what you all have been talking about. The plaintiffs are trying to have their cake and eat it too, because on one hand, they argue about how the Home Rule Amendment affects the counties, and then on the other hand, they argue about how it affects the school districts. So let's take them one by one. In terms of the counties themselves, the answer is it doesn't affect them at all. They have no injury, in fact, and therefore they lack standing to bring this claim. What the counties have that they talk about in their brief is they simply have an education mandate, not an ESA mandate, an education mandate. They have to pay the local portion of the BEP for every school-age child in the county, period. If that child goes to the county school system, they pay the local portion, state pays the state portion. If that same child receives an ESA under the statute, it's exactly the same. They pay the local portion and the state pays the state portion. That's why the Legislative Fiscal Review Committee report that was referenced in their brief calls it a shift in funds. It's not a new expenditure on behalf of the local government. It's the same money that is shifted. So the counties also complain about the maintenance of effort statute, and they say, well, that requires us to pay the same money toward education that we paid last year, unless the number of students drops. Well, of course, the maintenance of effort statute applies. They owe the same amount as last year. They have to keep funding these children just like all other children. So the amount that they pay for students is exactly the same, whether the child goes to a county public school, a county public charter school, the Achievement School District, or now the ESA pilot program. Therefore, there is no injury in fact and no standing.
Well,
now, second
what
of all,
about the fact that this money is shifted, as you put it, from public schools to non-public schools? I mean, the constitutional provision on education says maintaining public schools. So isn't shifting it to a non-public school an injury?
Respectfully, Your Honor, it's not an injury because, again, that is a policy decision that is within the realm of the legislature to make. The counties are right that they have.
Doesn't mean it's not an injury, does it?
It does mean it's not an injury, Your Honor, because the policy decisions about education are not what's left to the counties. It's the funding that's left to the county governments, the funding only. That's their role in the so-called partnership that they claim about. So the only injury that they can claim is to the part of the role that they've claimed, which is their funding. And that's not an injury to their funding. What happens to the money after it leaves their hands, that's up to the legislature to determine what is education policy and how is it best spent to educate these children.
What about there is a reimbursement provision though, right?
That's right, Your Honor. And so that gets me to the second half of the question, which is how does the funding affect the school districts? And there it is a different analysis. But there, the answer is very simply, they have a benefit. They actually come out better out of this program. There are 3 different ways that they do that, which are explained in detail in our brief. But the simplest one to explain to you is that at least for the first 3 years, that the school districts get paid a second time for the same child. There's an extra reimbursement. We call it a ghost reimbursement for another child who's not there. And so they get extra money for 3 years paid for by the state. So
that's not guaranteed though, right?
I'm sorry, go ahead, Judge Bennett.
It is guaranteed as much as the legislature can guarantee it under the statute in the sense that it uses the word shall in terms of the funding. But you're right, Your Honor. Of course, it's possible that the legislature could refuse to appropriate for it. And I would say at that point,
the legislature provided for the possibility set by being subject to appropriation.
Well, the legislature also used the word shall appropriate, Your Honor. And if that happens, then perhaps the case would be ripe at that point. But at this point, it is not ripe because the legislature in every iteration of this law has in fact appropriated those funds. So at the end of those
shall
years,
disperse an annual grant, but before that it says subject to appropriation. So whenever something's subject to appropriation, it may not happen, or it may only happen in part. Is that correct?
And if it does not, in fact, happen, Your Honor, then at that point, the case would be ripe for them to bring that claim. But we're not in that situation. The legislature did fund it until the chancellor struck down the program. The legislature
What about
did
other expenses? What about who pays for the testing for these students?
The factual record was not 100% clear on that, and so therefore the plaintiffs are claiming that they have to pay for it. But the payment of it is ultimately it's going to have to come out of the ESA, and that's the whole point. The ESA pays the same amount of money out of the ESA funds.
Okay.
The ESA is the same amount of money for these children, whether they're in the public school system or whether they are in the ESA program. Either way, it's the same amount of money that's going to pay for all of these things. And so
the reimbursement that you're talking about, it's for 3 years. If it's appropriated, it's for 3 years, correct?
That's right, Your Honor.
So under the statute as enacted, it says right now it ends in 3 years, unless the General Assembly does something else.
That's right, Your Honor, because remember, this is a pilot program.
Why is that not, I mean, how long is this pilot program set to last?
At the end of 3 years is when the evaluation comes from the Office of Research and Education in the Comptroller's office. And so that's when it will be evaluated for continuing the program or expanding it or making it smaller or contracting it or ending it. The 3 years basically gives a huge cushion for the counties to make any sort of transition, for the county school districts to make any sort of transition that they need to make.
What do you say about the counties? And I know your time's up, but what do you say about the argument that, look, there are a lot of expenses that a county school system has funded by the county that remain the same. If you have a school with 1,000 students in it, and you've got a principal and all the administrative staff and the custodians for the school building, the cafeteria, all that equipment, and if you take 100 students out, and you now have aren't you dividing those fixed costs by 900 in effect instead of 1,000?
Yes, Your Honor, and that's covered by one of the other 3 windfalls that we identified in our opening brief, and that one is that not all of the ESA, not all of the local BEP funds go with the student. In fact, the student only takes a portion of the BEP funds and leaves a portion behind that will forever, in all years in the future, pay for such transitional type of costs. So that does not end at the end of 3 years, Your Honor.
On the reimbursement funds, is there a limitation as to how they can be spent?
Your Honor, it's a very vague limitation. It says that it's supposed to be spent for those struggling schools, but they can spend that however they want to with the budget as large as theirs.
I'm sorry, I thought, doesn't it?
But it said school improvements or
School
something.
improvements, thank you, Judge Bennett. Yeah, isn't it a limitation that it's for school improvements?
Yes, Your Honor, and I would argue that
Is the county's money generally limited to school improvements?
Your Honor, generally it is not. So again, there are 3 different windfalls that they're receiving. One of them lasts every single year. They are left with this extra money because not all of the local BEP leaves with the students. So that windfall lasts every year, and they can pay for all these transitional costs each year. On top of that, they also get a full entire extra ESA grant, fully funded by the state. 0 of that part comes from the local governments. Is fully funded by the state, and that gives them that portion for 3 years to move around any sort of fixed costs that they might need to, because all of the studies show that it only takes 2 or 3 years to transition on these things. They lose, metro schools and Shelby County schools lose students all the time. For example, they have decreasing populations, and when that happens, they don't get less funding from the state.
I think we've gone beyond the question, though, when I was asking if there simply wasn't a limitation on the reimbursement. And the answer is yes, under the statute.
The answer, Your Honor, is yes. It is a limitation that is not very limited in its actual practical effect because school improvement is vague.
Well, we like to believe the General Assembly means things when they put them in statutes. So if they included the words, they must have meant it to mean something. Thank you for your time. You have your time for rebuttal.
Thank you, Your Honor.
We'll hear, I guess, now from the appellee. I think that's where we are.
Yes, Your Honor. Good afternoon. May it please the court, Bob Cooper, Director of Law for the Metropolitan Government of Nashville and Davidson County, arguing on behalf of the Metropolitan Government and Shelby County Government. Now, despite what's been said over the last 30 minutes, this is a straightforward case. The ESA Act applies only to Davidson and Shelby counties, now and in the future. It takes their money to send their students to private schools, and it does this without the county's approval. The Chancellor correctly held that the ESA Act violates Article 11, Section 9 of the Tennessee Constitution, the Home Rule Amendment. Now, many of the objections that you've been hearing and reading to the Chancellor's ruling, both on standing and the merits, are based on one assertion, which is that the Act has no effect on the counties. That argument takes several forms, that it applies to LEAs, not counties, that the counties can show no budgetary injury, that the counties aren't required to do anything or to fund anything. But this court should follow the guidance by the Tennessee Supreme Court in Ferris v. Blanton and look beyond the rhetoric at what the Act actually does. This dispute centers on the funding and operation of local public schools. There is shared authority, as has already been discussed, among the state, local education boards, and county legislative bodies in providing public education. Under this shared authority, school boards operate the schools and county legislatures levy taxes for schools, appropriate money for schools, oversee the use of these funds, and issue bonds to build schools. The ESA Act explicitly affects this shared relationship in multiple ways. First, the Act changes the nature of the education partnership itself by requiring that the counties and their school districts that they participate in a program of privatizing public education. It thereby deprives the counties of local sovereignty, of the ability to operate a system of common public schools, like every other county and city in the state. But the impact is even more direct. Under the ESA Act, the state will give each participating student an annual amount equal to the average state and local per pupil funding under the basic education program. Then the state takes the full amount of that award, both the state and local shares, out of the money it would otherwise pay to the school district. In other words, what the state gives to the student, it takes back from the school district. So funding these accounts is not going to cost the state a dime, but the school districts will be left with a huge deficit. Just look at the Act's fiscal memorandum. The shift in BEP funding for the school district starts at $37 million in the first year and grows to $111 million annually by year 5. The Act then makes the county legislatures fill that budget hole. County funding for schools is based on enrollment. When a public school student leaves, the county no longer has to appropriate money for that student. But an ESA student attending a private school will still be counted as enrolled in the district, quote, for the purpose of funding calculations. That's section 2605 of the Act. Under the state maintenance of effort statute, counties cannot reduce their school funding year to year unless enrollment drops. So appellees will have to continue to fund their schools as if these students are still there. Financially, this is like the Hotel California. ESA students check out, but they never leave. Furthermore, both Davidson—
So what you're saying is even if a student leaves the county school system and goes to a participating private school, in terms of the county system still has to count that student in terms of what it's expected to appropriate itself for the school system.
That's exactly right, Your Honor. Even if the student goes to a private school in another county, the county will, Davidson or Shelby will still have to do that. Now, furthermore, both Davidson and Shelby counties fund their school systems beyond the minimum BEP requirements. So the counties will be required by the ESA to pay not just their BEP share for every ESA student who no longer attends their schools, but also this additional funding. There could be no more fundamental effect on the county's taxing, budgeting, appropriation, and operational capacities than to impose this unique burden on how they pay for public schools. Now, similar math applies to schools in the Achievement School District, which are only Davidson and Shelby County schools. The only difference is that the funding for the ASD schools comes from the school districts, not the county legislature. So the school districts will take the financial hit for the ASA students in the ESA program, and they will no doubt look to the county legislature for help. This is not the only way, as you've already mentioned, that school districts are harmed by the ESA Act. Again, according to the Act's fiscal memorandum, school systems will have to spend millions of dollars, additional dollars, on providing federally mandated education programs for ESA students and administering assessment tests to ESA students.
Now, Mr. Kelsey said that you wouldn't have to pay those standardized tests, but you say you do.
There is nothing in the record that supports Mr. Kelsey's position. We would refer you to the fiscal memorandum issued by the legislature in connection with this act, which clearly says that this is a local financial impact of the act.
Okay.
Now, we've also heard about the school improvement grant program, which allegedly is going to make the counties whole. That is not the case. As the court has already pointed out, the grant program is an unfunded mandate. You've also pointed out the grant program only lasts for 3 years, whereas the ESA Act is perpetual. The grant program will not be around in year 4 or in year 5 when the loss in BEP funding hits $111 million. It's a school improvement grant, as the court points out, so it will have strings attached. But most significantly, the grant program does not relieve the counties of their obligation under the Maintenance of Effort statute to continue to pay for these ESA students. Maintenance of effort is satisfied only with revenue derived from local sources, according to State Board of Education rules, and the grant money is revenue from the state. Now, Your Honors, with that setting, let's look at the 3 Home Rule Amendment factors. First, the act is clearly local in form or effect. Only the appellee counties fall within the act, now and in the future. Now, if the act had the potential to expand and contract in the future, it would not be local under Ferris, but the way the act is written, that can never happen. Next factor is applicable to a particular county. The second element is whether that is applicable. And appellants seek to elevate form over substance here by arguing that the act is applicable to LEAs, not counties. We've already outlined the many ways that the act applies to both. And Ferris warns against elevating form over substance because relying on the nomenclature employed by the legislature would, quote, emasculate the amendment. Now, in response, appellants claim that we confuse the terms affect and apply. Well, if we're confused, so is the Tennessee Supreme Court. In Chattanooga-Hamilton County Hospital Authority, the court rejected the city of Chattanooga's challenge to a private act, saying that the city was not, quote, substantially affected by the act. And in contrast, the court said several sections of the act, quote, affect the county, justifying the county approval provision. Now, let me speak to that just briefly. Mr. Panju suggested that there was a significant effect on the city because of the transfer of jointly owned city and county property to the hospital authority. Well, if you read closely the private act that is at issue in this case, that issue is not before the court. This was a challenge to a 1977 private act that amended the 1976 private act that created the authority. It was the 76 Act that transferred the property into the authority. Striking down the 77 Act would not have changed that at all. So that was not an issue in terms of impact on either county. In fact, what the city was concerned about in Chattanooga-Hamilton County was a provision that said if the authority in the 77 Act that said if the authority went out of existence, the property would be transferred to the county. But there was also language in that same provision in the 77 Act that said the city could invoke its ownership right on a pro rata basis if it so chose. And on that basis, the court concluded that there was no impact on the city. And finally, even the Attorney General opined in 2002 that 2 counties, quote, would be affected, close quote, under the Home Rule Amendment by a bill creating a special school district if the bill transferred county-owned property to the district. So, affect versus apply, this is a semantic distinction without a difference.
So what is your position on the language applicable to a particular county as whether it includes 2 counties or not?
Certainly, Your Honor.
And I know you mentioned the AG opinion, but I think there's probably more to it than that.
Well, there's more to it than that. The AG opinion is simply following clear Supreme Court precedent on this issue. The Supreme Court has already ruled in Leach versus Wayne County, where the court applied the Home Rule Amendment to a legislation exempting 2 counties from an act of general applicability. This is controlling Supreme Court authority. It is supported by the records of the 1953 Constitutional Convention, and it makes sense. Any numerical cap would be easy for the legislature to circumvent. The point is that the court should look at whether the act is intended to be local in effect.
If an act, instead of, most of these cases on this provision deal with population brackets.
Yes.
And this is a different animal here. What defines and limits the counties or the application to the counties is the criteria for eligible student. And that criteria limits it very clearly, very intentionally to 2 counties, as we know, and it can never apply anywhere else. Does that make a difference? The way that this act is done, as opposed to the way some of the other acts are done through population brackets?
No, I would refer the court again back to the Ferris case, which says you don't look at the nomenclature. You don't focus on the nomenclature used in the act. You look at what the act actually does. In fact, while many of the cases do conveniently use population brackets to identify the particular county or counties that are subject to the act, other acts that have been challenged under the Home Rule Amendment used, for example, the nature of the government, whether it was a metropolitan government or not, or used the type of election system that it used. It really doesn't matter what is used as long as it is an effective way to identify the counties to which the applicability of the act is limited.
So the fact that we have 2 counties that are described by very specific criteria. Doesn't make this any different from Ferris about the election of people or any of the others. It's the same sort of thought.
Exactly, Your Honor. It is the same sort of thought, and to the extent that there is any concern about that, then the cases suggest that you look at legislative intent. And the legislative intent here could not be clearer. There was horse trading in the legislature about getting senators and representatives, counties out of the bill in order to get their support. So there was very clear intent to limit this just to two particular, as they said, deep blue metropolitan areas.
Is there any line that can be drawn here about how many counties something could be if and still remain local, or does it depend on the situation?
Your Honor, I think it depends on the situation. You saw the colloquy in the Constitutional Convention. The drafter of this language every time push back against putting a particular cap on there. It depends on the intent of the legislation, the intent of the General Assembly. I think it's fair to say that the larger number you get, the harder it is going to be to show that that bill is local in form or effect, and harder to show that there was a legislative intent to do that. But to put a hard cap on it simply invites game playing by the legislature, which was the intent to avoid with this amendment.
Let me ask you about some language in Ferris that has always confused me. In Ferris, it says, we must determine whether this legislation was designed to apply to any other county, which kind of sounds like one county only. For if it is potentially applicable throughout the state, it is not local in effect. So really, if it applies to another county, it's not necessarily a general law yet. It still have to look at the circumstances and all that.
That's correct. That's correct. As Delegate Pope made clear, that the typical local bill, the typical private act does just generally apply to one jurisdiction. But if you limited it that way, it would be extraordinarily easy for the legislature to circumvent the clear instructions of the Home Rule Amendment by simply sliding another jurisdiction into the bill.
Thank you.
Certainly. So appellants also argue that we are claiming.
I'm sorry, before you move on,
yes,
so is there any scenario under the act as written now, without the act being amended, that the only two counties it can ever apply to are the Davidson County and Shelby County?
There is no way for any other county to come into the act. That was deliberately done by using the number of low-performing schools in specified historic years. It's based on years that have passed. That data can never change. And so, no, there is no way for another county to come into the bill.
Let me ask you one more question here, a little different here. Looking at just the first 3 years where the act does provide the reimbursement for the funds spent, do the counties suffer a financial impact, or does it affect the counties financially? Just looking at just those first 3 years, and if so, how?
Yes, Your Honor. It very definitely impacts the county legislatures. Again, you're referring to whether the grant funding somehow provides 3 years of relief. That grant funding goes to the LEA but that grant funding in no way relieves the obligations of the Shelby County Commission and the Metro Council to fully fund those ESA students as if they are still enrolled in the school district. So maintenance of effort requires the counties to fund those students, that enrollment, notwithstanding the fact that the school district may get grant funding in addition to that. And that is because grant funding from the state has no impact on maintenance of effort. In fact, the whole idea of maintenance of effort is to require local governments not to supplant state funding, additional state funding. So an increase in state funding in no way relieves the obligations of legislative bodies under maintenance of effort.
Would you say the legislation affects the counties and their governmental capacity by the requirement that they continue to count students that are no longer in the school system? Is that the governmental capacity application here?
Well, I think that is one governmental capacity application. Yes, Your Honor. But the Supreme Court precedent that says that the function of local government in providing a system of education is in whole a governmental function. So, I think all aspects of how this impacts the function of education at the local level impacts a governmental function. One part of that, and a very direct one, is this requirement that the LEA the school district continue to count these students as enrolled, which then requires the counties to pay for them. That is certainly part of it, but I think the governmental function is more broadly the entire operation of the school system. Let me say a word, if I could, about the Parrott case, since that came up in argument before. The appellants point to that to support their argument that legislation about LEAs does not fall within the Home Rule Amendment, regardless of how it might impact a county. That is not what Parrott held. Parrott simply held that special school districts are not covered by the Home Rule Amendment. And since a special school district is not affiliated with a city or a county, that is not surprising. Now, appellants have asked why plaintiffs did not bring a claim in the name of the county. That was not an issue in the opinion, but a review of the private act at issue in the case provides an easy answer. This special school district, the Huntington Special School District, was created initially by private act in 1919. So obviously the county could not have challenged any funding or other impact at the time under the Home Rule Amendment. The 1957 private act simply expanded the district's boundaries. In moving students from the county into the special school district did not affect the county financially under the funding formula that was in the 1919 Act and could not have been challenged retroactively, or frankly, nor would it have affected funding under general law. The two are essentially the same. Now, what would have substantially affected the county was that the expanded boundaries of the school district covered 2 county-owned schools. In anticipating the problem that was identified in that 2002 Attorney General's opinion, the 1957 private act explicitly excluded both schools from the special school district. So there was no effect on the county to support a Home Rule Amendment claim. In fact, the more you dig into Parrott, the more apparent it is that it supports, not undermines, the chancellor's ruling below. Now, let me turn finally to the final of the 3 factors, and that's governmental or proprietary capacity. Now, these are well-defined terms in Tennessee law. Governmental capacity relates to state function, proprietary capacity relates to municipal function, and when you put them together, as the amendment does, It covers the whole waterfront of what a county does, as the Supreme Court recognized in Ferris. Now, the state has argued that because education is a state function, that it is not limited by the Home Rule Amendment. We agree that education is a state function, but the state has shifted most of that function to local government. And that means that appellees are engaged in a governmental function, and that therefore falls within the Home Rule Amendment. The state has not cited a single instance in which a court has held that education is exempt from the Home Rule Amendment. In contrast, Shelby County brought a successful Home Rule Amendment claim or challenge to a state education law in Board of Education of Shelby County. And the Supreme Court allowed local school systems to challenge state education policy in Tennessee small school systems. Now, this is not an education case, but Your Honors, we think that the decision in Lawler versus McCandless is instructive. It's like education, the General Assembly has no obligation to involve counties in the state judicial system. But when the General Assembly transfers state authority to a county court, it has engaged the county in a governmental function, and it must comply with the Home Rule Amendment. So when the General Assembly granted additional state court authority to the General Sessions Court only in Gibson County, it violated the Home Rule Amendment. Now, appellants have suggested that you should graft equal protection jurisprudence into the Home Rule Amendment. They rely on an old line of cases in which the Supreme Court applied a balancing test to see if legislation fell within Article 11, Section 8. Now, for many years, Article 11, Section 8 was held inapplicable to cities and counties, and this balancing test was used to determine whether the primary purpose of the act was to affect local government or private rights. If governmental, it was exempt from equal protection. If private rights, it was subject to equal protection. But a bill can obviously do both, as the court said in State Ex Rel Scanlon v. Trotter. But of course, the Home Rule Amendment had not been adopted in 1926 when that case was decided. The 1953 convention notably did not incorporate this balancing test into the Home Rule Amendment. The amendment doesn't say anything about the primary purpose of a bill being governmental or proprietary. Instead, the Supreme Court has said in Chattanooga-Hamilton County Hospital Authority that the Home Rule Amendment is triggered when a local government is, quote, substantially affected, close quote, in its governmental or proprietary capacities by a local bill. And the ESA Act's effect on appellees is clearly substantial. Again, you can just look at the fiscal memorandum for a start. Now, Your Honors, at this point, it should be clear that appellee counties have standing to assert this claim. The counties will suffer a distinct and palpable injury. The ESA Act will cause that injury, and the Home Rule Amendment provides a judicial remedy. All the criteria for declaratory judgment standing have been satisfied. Now, in conclusion, Your Honors, this is not a complicated case. The ESA Act applies to only 2 counties, and it has a substantial effect on those counties' finances and sovereignty. If the state wants to take over providing public education in Tennessee, it wouldn't have to worry about the Home Rule Amendment. But it has enlisted local government to play the primary role in education, so it must treat local governments equally or else get local approval. This is a case for which the Home Rule Amendment was designed for. The Chancellor correctly held that the ESA Act is unconstitutional under the Home Rule Amendment, and we respectfully ask this court to affirm the Chancellor's judgment. Thank you, and I'm happy to answer any other questions. Thank you, Your Honor.
We'll hear from the appellant's rebuttal now. You need to unmute. exactly what I just did too.
Thank you, Your Honors. It is the county's obligation to fund the LEA. The ESA does not affect the county's funding obligation. It is revenue neutral. Let me suggest to the court that there is a presumption of constitutionality that attaches to the legislature's enactments, which of course this court should respect. The maintenance of effort that our learned adversary referred to is a statute of general application, and one that does not harm the counties under this circumstance. Your Honors, the state has, and under the ESA program, maintains the responsibility for educating the children under the ESA. Your Honor, the matter in the Pruitt case involved the fact that the special school district at issue there was not a municipality or county, and thus did not come under the rigors of the Home Rule Amendment. The same is true of the LEAs here. We submit, Your Honor, that the path is relatively clear for the court, that the court should follow Dossett and State Ex Rel Cheek versus Rawlings and find that a state function is in view here and have respect for, of course, the legislature's authority over state matters. In reference to the references to the Ferris case, Your Honor, we would submit that the Ferris case does not involve education, which of course is a state matter, and that the ESA program does not tinker into the governmental affairs of the county. Under these circumstances, the counties lack standing, and the court, we submit, should reverse the rulings below and remand to the Chancery Court with instructions. If there are no further...
The state's duty for education is to provide for maintenance, support, and eligibility standards of a system of free public schools. How does sending students to participating private schools under the ESA advance that goal?
Well, Your Honor, the counties have not attacked the policy per se in this circumstances, and the legislature has the power to adopt legislation, the intention of which is to improve education in the LEAs itself. And we don't know the reasons why, but if that fosters competition in the schools that are operated by the LEA, perhaps that is what the legislature may have had in mind. And if there are no other, Your Honor.
Thank you.
Thank you.
I think that's it. We'll hear from next, please. You're still muted.
Thank you, Justice Wyman. The parents interveners want to make 2 points on rebuttal, Your Honors. The first is to point out that nowhere in the 30-minute presentation by the Metro plaintiffs did they point to any authority that supports this mere financial effects theory of theirs. And they try to distinguish the Chattanooga Hospital Authority case, but fail to do so. There were 2 acts at issue in that case. That is true. One created the authority and tasked it with operating hospitals. But then the 1977 Act, Act number 2, is what actually required the transfer of hospitals. Here's what the act actually says, the one that we peg our argument on. Quote, the city and county are authorized and directed to convey and assign all real property constituting, and then it lists the hospitals out. And that's why there was a stay in place And that's why the court had to say what it said before it dissolved the stay. Mere financial effects is insufficient, and that case is fatal to their theory. Second, Your Honor, something that's also noticeably absent from Metro's presentation is any explanation for why this court should ignore the plain text of their charters, which expressly prohibit them from interfering with educational options, county education funds, etc. They don't have the power to do so under their own charters. And Shelby's charter was promulgated pursuant to the Home Rule Amendment. The ability to interfere with educational options is outside of their governmental and proprietary powers that are contemplated under the amendment. And they make no effort here at oral argument to dispute that. That's because these are—
Counsel, let me ask you a question. How does, understand your argument there, but how does that apply to the only two issues in front of us, standing and the constitutionality of the statute?
Right. So
whether or not they have the authority to do it or not,
yeah,
under the charter.
So the issue that we're dealing with in this case relies on paragraph 2 of the Home Rule Amendment and requires that a law be applicable in a governmental and proprietary capacity. Paragraph 5 of the Home Rule Amendment says that charters provide for the governmental and proprietary powers of a county. They don't have the power, which is why they have to advance an effects theory to do an end run around their own charters. This court should—
but how does that, are you saying that applies either to the standing issue or to the constitutionality of the statute?
This applies directly to the constitutionality of the statute because it makes clear that the ability to interfere with educational options, direct benefits, do not extend to the governmental and proprietary powers that the Home Rule Amendment contemplates. And
so the constitutionality of the statute depends upon the charter?
What we're saying is they're asking the court to exercise the Home Rule Amendment's power to extinguish direct education benefits. We say that their charters expressly prohibit them from interfering with direct education benefits altogether. So we can't construe the Home Rule Amendment.
So your argument is that the law can't be applicable to a particular county in its governmental capacity if that capacity does not include this sort of infringement upon educational choice.
That is absolutely correct, Your Honor. These are direct benefits. Those limits enshrined in the charter should be given full force and effect. They were put on paper and authorized by the voters in those jurisdictions to do exactly what they're designed to do, impose limits. And that has to carry weight in the Home Rule Amendment analysis because the counties are trying to trigger the amendment to extinguish the very educational benefits that the charters prohibit them from interfering with. That has to inform the analysis here, Your Honors. And with that, we ask the court to uphold the ESA pilot program and reverse.
Thank you. Ms. Kelsey.
Thank you, Your Honors. 3 quick points. First of all, the Chancellor erred in her argument because her reasoning should have led her to sever the statute, and she should have left the program to go forward in the Achievement School District. Clearly, there's no application of the Achievement School District to the counties or the county school districts. On the county side, as we said earlier, they fund the same local proportion of the BEP regardless of where the money goes. And then on the school district side, they have nothing to do with the Achievement School District. It is entirely state run. Second of all, Your Honors, there's again, on this funding issue, as we've said, for the county, the funding is the same, but their interests diverge from the school district, which actually wants more money. The county wants to pay less money. The school district wants more money. Well, they get it with this bill. And I would point, Your Honors, to this left behind windfall. It's the first one that we mentioned in our brief. It lasts every year going forward, and it's up to, according to the record, $4,000 out of the $12,000 or $13,000 per student. $4,000 is left behind in the school district for each child that gets the ESA. So they should want even more students to take it. They benefit from this. Therefore, there's no injury in fact and no standing. And finally, Your Honors, there have been 7 cases that have actually upheld the statute. And in 4 of those cases, even though the statute applied to only one county, it was still upheld. There have only been 4 cases where the Home Rule Amendment has said that it does not apply. And of those, they were actually targeted at affecting a particular local election or reversing a recent action of a locally elected official. That's Lawler, Ferris, Board of Education, and Leach. That happened in all 4 of those cases. This is the exact opposite. The governor is providing a benefit to children, not reversing a local official's decision or a local election.
We'd like to thank all counsel. The case is obviously very well briefed and very well argued. The issues are very clear, and I think we understand everybody's position. So we thank all of you for that. Mr. Chairman, if you would please recess court till the next case this afternoon.
This honorable court is now in recess until 3 p.m.